welcome to Labour Lens. I am Sharon Ijason. On this week edition of the program, we'll be focusing on the right of workers to join the union and freely associate. We also have news stories for you. We will be right back.
What began as a tense standoff between oil workers union PENGASSAN and the Dangote Refinery has now been resolved, following government-led negotiations. The crisis erupted after the dismissal of more than 800 workers at the refinery, shortly after they joined PENGASSAN. The union described it as victimization and launched an indefinite strike that paralyzed the oil and gas sector. The first reconciliation meeting convened by the federal government lasted 9 hours, but ended in a stalemate. By Tuesday, 30th September, the negotiation meeting moved to the office of the National Security Advisor, where government officials, labor leaders, and Dangote management reconvened.
There are issues that we are still addressing, and we have agreed to reconvene to continue with the meeting. There are other issues now, issue of unionization. These are two basic issues that we have been discussing.
By early Wednesday, October 1st, the chief conciliator announced that progress had been made. Among the resolutions was the reaffirmation that unionization is the right of every Nigerian worker, in line with national laws. Dangote Group also agreed to begin the process of redeploying the disengaged staff into other companies within its conglomerate.
We need to limit the damage to the economy of this action. We need to wrap it up, we need to resolve it, and we need to have workers going back to work. We need to have the gas flowing, we need to have crude flowing as inputs into production, which is where the economy is arrived at right now, where we are able to add value, where we are able to grow the economy, and we don't want that momentum to be broken. And that's why you see us here for 9 hours trying to resolve just one knotty issue, as the Honourable Minister for Labour and Employment has said. And we are optimistic that by tomorrow we will break the deadlock, we will resolve the stalemate, and we will put this issue behind us.
All we want is that we have 800 people plus that are at home. These people, they are fathers, they are mothers, their career is at stake. When you terminate people the way you've terminated them, it will be extremely difficult for them to find job anywhere. Some of these people are trainees, and you said they have committed sabotage. So if they go home like that, there is no other company they will get job to do again in Nigeria, because they have seen them as saboteurs. So these are careers that will be damaged if proper remedy is not put in place. So that is why for us, our position has been very clear. You have to reinstate these people.
Hours later, PENGASSAN convened an emergency session of its Central Working Committee and National Executive Council. While expressing dissatisfaction with some aspects of the outcome, the union suspended its strike out of respect for government intervention.
Even with our misgiving that the document did not clearly represent what we have asked for, that we will go ahead to suspend the industrial action that we started on Sunday, 28th day of September 2025.
But the union has issued a clear warning. If Dangote Group fails to keep its side of the bargain, the strike will resume without notice.
Remember, we are suspending, and we will be monitoring. We will be following closely any slip on the part of Dangote, any part of this agreement, or any part of this communique as put up by the Ministry of Labour that is broken. We will not give any notice. We will not give any warning. We will resume the suspended industrial action immediately.
The truce has brought temporary respite to Nigeria's oil and gas sector, but the test of peace will lie in the coming weeks as workers, management, and government monitor compliance with the agreement.
On the Profile Interview segments this week, I'll be speaking with Barrister Folabi Kuti, SAN. It tells me what the law says as regards the dispute between the oil and gas workers and Dangote refineries. It's good to have you on the program.
Thank you very much. The pleasure's all mine. Yeah.
We have witnessed disputes between organized labor, particularly the oil and gas workers, that is PENGASSAN and NUPENG, and Dangote refineries. Looking at the issue, which is the company refusal for workers to join the union, what does the law say as regards this dispute?
Thank you very much for the question, which from the way it's been phrased, gives me some flexibility in addressing the issues on broad statement of the law without necessarily seeming to take a position from the competing position or the respective position, diverse position put forward by the two parties, whether the employer or the union, because as it is, those are just facts in the public domain. It's not been tested as established facts on either side. But that said, I should still like to take my bearing from the fact as publicly stated. From what's been put out, it would appear that Dangote management is openly opposed to organized labor coming to unionize its workforce, whether the senior or the junior, and there's been a backlash that has led ultimately to the termination of 800 members of staff. I'd like to say that if those facts are taken to be so, without any equivocation, that is absolutely wrong. Within the letters of the law, the individuals, workers are entitled, they have a right, it's constitutionally protected to unionize, to associate, can be expressed. And beyond the letters of the Constitution in Section 40, it would interest you to note that even on the larger scale of the International Labour Organization understanding of conventions, specifically Conventions 87 on the right to associate and Convention 98, which deals with collective bargaining, and also frown at that kind of factual scenario. It specifically states that, or provide that workers can come together to associate. And within the letters of the law, well as expressed or interpreted by case law, that right to associate has also been extended to mean the converse, even the right to disassociate. So let's bring it home. Now, NUPENG, which is the union, organized labor for junior workers in the extractive industries, whilst PENGASSAN is for the senior cadre workers still in the same extractive industries. The publicly available fact seem to or suggest that Dangote kicks against having the unions within his own workforce. And like I said earlier on, the law frowns at that. But beyond all of that, it would also interest, and it's important or it's imperative to also examine it from the perspective of the unions. What rights do they have where they're faced with that kind of scenario? And in the light of what we've had recently, which is the reference to the fact that organized labor actually called out those within that particular sector. There was a strike action that to some days was on for about 2 or 3 days before it was called off. What is quite worrisome about all of this is that when we have situations or we have scenarios like that, what organized labor tend to resort to would seem to be totally a divergence with what they understand, what the law provides. And then this is where this comes in. Once there is a fact scenario like that, what the law expects is that a trade dispute is declared. When a trade dispute is declared, the organized labor is expected to follow through the internal grievance remedial measures provided for in the law. But beyond all of that, there is also a worrisome trend, which I think is important to address at every point in time, especially coming in the wake of what we just witnessed, the complete shutdown of the gas supply chain as a result of the strike that was declared by the by PENGASSAN. And for 2 days, or about 2 or 3 days, not only the employer that was affected, I mean the employer that's affected or that's caused whatever the issue was, had to bear that brunt. There was a secondary strike or sympathy strike whereby virtually all the players in that particular sector, I mean all the employers, had their valves disconnected, had a complete shutdown of the operations, all just because of this perceived issue or grievance as against Dangote management. It's important to always bear in mind, as a matter of fact, it's imperative that union must always bear, must always know that they must operate within the letters of the law. Where there's a particular situation as against an employer that the union members of the organized labor is displeased with, you declare a trade dispute. And in declaring a trade dispute, you follow through the internal grievance remedial measure expansively provided for in Part 1 of the Trade Dispute Act. Not only that, whatever is being done must, before strike can even be declared, must again still follow through the stringent provision that you have in the Trade Unions Act, the Amendment Act of 2005, where in sections 26, it is expected that before an industrial action like a strike is declared, there must first be a written notice to the employer of the perceived grievance, and this is what that's the likelihood of an industrial action being declared unless the complaint or grievance is addressed. And at the end of that, I think the Trade Unions Amendment Act of 2005 also introduces Section 27 that there must be secret balloting, just to show that the decision to have an industrial action, the decision to go to strike, is truly representative, an indication of the wishes and the will of the members of the particular union. And it is all when that is complied with that a strike can be validly declared.
But remember,
it takes us back.
Okay.
It takes us back. So let's apply to the fact of what is just transpired. It's important. I will not say that was not, but we need to ask, was there a written notice to Dangote Refinery of 15 days? If there was there a written notice to all the other employers in that sector of 15 days of intention to declare not just a strike against Dangote, but also a secondary sympathy strike that would affect everybody in that industry? Was there a secret balloting of the members of the union in all the various, I mean, virtually all the players in that particular industry, I mean, the employers, you know? If that was not done, one wonders whether that really happened. I would not like to draw a conclusion that there was no written notice, but I can almost tell that, and this is where the aspect of the secondary strike, the sympathy strike, that in a particular sector, the trade dispute is in relation to what a specific employer did. Now, one would have expected that that trade dispute would be limited to that. But what you have is that there was a strike action that affected virtually all the whole sector because there was a shutdown. It was a complete shutdown. That is more like a sympathy strike. Now, within the letters of the law, that is almost not acceptable unless certain conditions are in place. So, because it causes a disruption to the whole system, and there must, at every point in time, the philosophy behind those laws is that we must promote harmonious industrial relations so that we don't find ourselves in a situation where there is what's been alleged, economic sabotage, affecting a destruction of the whole system.
But typically, from my experience, I've covered labor for at least a decade.
Yes.
Employers and employees oftentimes do not trust the system. They believe it can work, but there's also this aspect of it takes time.
Yes.
And 800 people have lost their means of livelihood.
Yes.
They are seeking, they are eager to know what next.
Yes.
And the union, of course, maybe they're under pressure to ensure that they protect the rights of these people that just are about to join them. Yeah. So what do they do in this kind of situation?
Fantastic. Let's start by identifying that two wrongs will never make a right. So if indeed Dangote had acted wrongly, it is not the decision to declare a strike, knowing fully well that this is not in accordance with what the law expects. You have not followed through the internal grievance remedial mechanism expansively provided for in the law. And to declare, to have whatever industrial action, have that toga of legitimacy, it is important that it is done strictly in accordance with the law. There is a need to understand what the letters of the law provided before we even talk about there's a need to go to the industrial court to get an immediate order. Dangote Refinery has sacked 800 persons, 800 workers. The question is that enough reason to shut down the whole gas supply chain system in the Federation when it is only one employer that organized labor could come after? That's the first thing, and that's what I talked about, secondary strike, that there's a need to look at the propriety of even having that, whether it falls in with the letters of the law. Then secondly, thumbing through the law, this situation had been envisaged as far back as when the Trade Unions Act was initially made in 1973, before the revision in 2004-2005. I can assure you that by the time we thumb through those letters of the law, when you go through section, I made reference to in the 2005 amendment, if you go to sections 26, section 27, there are clear, laid out remedial measure that the law has made provision for, where that is the result. Okay, the position is that Dangote has sacked 800 persons. In sacking 800 persons, what that takes is that they are being victimized for deciding to come join union. The law recognizes, and the statement of the law is that nobody should be victimized or should be punished for that. Exclusive court dealing with labor and industrial matters, they've been living up, or they've lived up to this billing. But assuming without considering that that is even the issue, the question is it a resort to the rule of brute or force that would eventually declare, or that would eventually get us to a modern day where rule of law is promoted, or the, God forbid, the dark days of probation nature, state of nature where life is short, brutish, nasty? I don't think that is the answer. Clearly, you must follow through what the law states to get whatever right you're seeking. You come to equity, you come with clean hands.
So are you saying that, I don't know, maybe this question should be for you.
Yes.
But are you saying that there is a need for the system to work more efficiently on matters that of urgency such as this?
There's no
subsequently,
doubts.
because there's a great silence now.
Yes.
The workers have called off the strike. No, they didn't even call it. They just suspended the strike.
Absolutely.
And we don't know the timeline.
Yes.
There was no timeline stated.
Yes.
And if the employer does not meet up with their own time, there's a possibility that they might actually commence the strike again. So how can the system be expedited on such matters that of urgency?
Thank you again for that question. Clearly, when there are gaps, identifiable gaps, the system would address and find a way to close on that. So I recognize that. But beyond all of that, and I think it's important, context should be brought into this. It's not so much about the system, but the two warring parties. On the one hand, the union, organized labor, and on the other hand, the employers. Now, within the context of the ILO, and that is why you have collective bargaining at every point in time, unions come together to discuss on behalf of individual workers with the employers on conditions of service. These eventually get reduced into the CBAs, the collective bargaining agreement. What I would say we should encourage and then promote at every point in time is that as between those parties, there must be negotiation, there must be discussion in good faith. And whatever is being discussed, there must be transparency as to both the commitment to implement and the implementation. The moment that works, there really would not be any need, because we shouldn't forget, the whole philosophy behind the industrial relation is to have an arbiter and not necessarily to have a court of law resolving disputes. And that is the whole essence where the Trade Dispute Act has set in place a mechanism that the moment dispute is declared, parties should get together to see how they can negotiate. And usually the negotiation is what leads to the collective bargaining agreement around all these issues. Then if they cannot, then they move on to the next stage of mediation, negotiation. The court is at the far end of the spectrum in the resolution of dispute. And the court sets in when either of the parties, so that is why it's important that there's transparency in the system before you get to the court. Either of the party fails to commit to whatever has been agreed to or to implement, then there can always be a resort to the court system to see how that can be dealt with.
Okay, throughout the few minutes you've spoken, you've been mentioning the International Labour Organization, The question now would be that we know that there are conventions, that support workers' unionization, that is the freedom to associate. And we know that Nigeria is a member country of ILO. So the question is, how implementable is this in the workspace?
Let me start by referring to the third alteration to the Constitution, which happened in 2010. Laudably, that third alteration is brought in place. A situation where a judge sitting in Lagos, in Abuja, in Port Harcourt, at the industrial court, for labor disputes submitted before the court, can look into what international-based labor practices are on the particular subject matter before the court, where there are gaps or the laws they cannot fulfill. The same thing, and within the context of that third alteration, the court has been enjoined to apply International Labour Organization Convention, the ILO Convention that Nigeria has ratified. Nigeria, as an example, the third alteration has allowed the courts to look into the convention. So that immediately answers the question that how are they being implemented there? Unlike a situation where treaties would need to first be domesticated, the argument has gone on that there is no need for immediate domestication. And on the other hand, if the argument is still that there is a need to domesticate before those conventions or treaties could be applied, case law citation has also said that with the coming into effect of the National Industrial Code Act, that domestication is already taken care of. So from time to time, the court has been applying those international conventions. I mean, one that usually comes up in many of the judgments of the industrial court is Convention 158, which we've not ratified. But the court has in many instances had to look at fact scenario that's been submitted within labor dispute before the court to situate in context how the rights of the employer to terminate must be within the letters of the convention or the understanding of the convention, otherwise it will be treated as unfair labor practice. So that is the same way those conventions generally get discussed and ratified.
Okay, very quickly we'll move on to the last, maybe the semi-last question. Yes. So what legal options do you think are available for workers to, in cases of perceived infringement in this kind of issue? Yes. Generally, I want your response on that, and I want in perspective on the Dangote issue. So if I'm an average worker that has been denied the right to unionize, what are the options for this worker? How does this worker seek redress? Because it is our right.
That denial can be challenged. The law, like I made reference to, has already made provision, clear provision as to how that is. So the union comes and the union complies with, declares a trade dispute, tries to negotiate to let the management know that it is their right, inalienable right, and is automatic membership. And where the management will still not budge, declare a trade dispute and follow through what the system or what the laid down mechanism has provided for in the law states, and it should be followed through.
Then in Dangote Refinery's case, the federal government actually they tried to talk to both parties. PENGASSAN has called off its strike. Dangote says that they will try and recall the workers if they do not follow through with that MOU. What are the options for the workers?
The options still remain virtually the same. We must go back the drawing board and understand what the law states should be done. The law has made clear provision for how they should be handled. Part 1 of TDA, like I said, makes a clear provision on before strike, lockout, and all of that can be, the moment that has been complied with, then they can validly declare strike. And in certain instances, can also go back to the Minister of Labor, make a reference where necessary to the Industrial Arbitration Panel, and once an award is made, if either party feels either way, ultimately end up in the industrial court. What is important is, it's not as if the law is silent. It is, and it would appear from one of the questions you've asked is that maybe we don't trust the system enough to give justice as quickly as we want. Well, justice at times may be a 100-meter dash, at other times it is a marathon. What is important is that we should not encourage a situation where we take laws into our hands.
Thank you very much for your time.
Thank you.
And that's all we can take on today's edition of the program. Join us next week for a fresh edition of the show. I am Sharon Ijason. Thanks for watching, and remember that labor creates wealth.